welcome. This is the first in our knowledge series hosted by Homecare Association of India. And we are starting with a topic that is actually on every healthcare leader's radar right now, the Digital Data Protection Act, or DPDP as we better call it, and how it impacts the home care ecosystem in India. I'm your host, Dr. Arnab Paul. Whether you're a founder, caregiver, a clinician, or a digital health innovator, this conversation is designed to make the complex understandable and the legal practical. Joining me today is someone whom I deeply respect, Mr. Sujeet Katiyar, director, founder of 14 Degree Azimuth Advisory India Private Limited, and he's a subject matter expert on DPDP, and he's actually advised a lot of public and private institutions to help navigate the shifting terrains of data, trust, and law in healthcare. So welcome, Mr. Sujeet, and it's a pleasure to have you here with us.
Thank you. Thank you, Dr. Arnab, and thank you, Home Care Association, for having me here.
So to begin with, I'm just thinking, someone who's new to this act, right? Can you just explain the basics, the philosophy behind this DPDP Act and how it aligns with or differs with the global regulations like GDPR?
Okay, fine. Good question to start with. I'll go in some history and some basic principles, and then the comparison with the other data privacy laws. So usually it starts with the 2017. That's how everybody explains. But I'll go bit back in the year 2014 when this Aadhaar Act was enforced, and data collection started. Though data collection started in 2009. But at that point of time, huge data collection was done by the government, whether it is your fingerprints, iris, multiple PIIs, your date of birth, so many things were there. But that point of time, government was not at least clear about how they are going to process the data, how they are storing. Though the Aadhaar Act suggests that it's for the government beneficiary schemes. Okay, so but again, it started uses in the banking, in the healthcare, in the education sector, but public at large was not clear about how data will be preserved, how data will be processed, used. And that's how multiple questions started there, and multiple petitions were there in the Supreme Court in the respect to this thing, Court of Laws. So in 2014, one Justice K.S. Puttaswamy, who was retired Kerala High Court judge, he came with this petition that I want the clarity around the personal data. Okay, whether this data privacy is a fundamental right or not. That was the question. And in 2017, one very landmark judgment came where the data privacy was regarded as a fundamental right. Okay, so once it is regarded, now it is from the judiciary to legislation to form the any law around it. So that process started. Okay, some Justice Sri Krishna committee was formed, and then after multiple iteration, post Justice Sri Krishna committee submitted some draft there. Then discussion started in lower house, upper house, so many consultations. In 2019, then the pandemic, and then 2022, multiple iterations were there. Many stakeholders were consulted because this is related to anybody and everybody who is collecting the personal identifiable information, PII. So in 2023, it was passed. It was enacted, signed by the president. Now, since 2023, it has been handed over to the executive, means to the government to implement it. So now around it, like some rules have been drafted, because who will be the body will be looking after this. So that process is going on. In this year, 2025, we got rules. And right now, we are waiting for the final rules and the date, which will be from when it will be implemented. So now coming to why this law? Okay, so this is a law. First of all, these are not the mere guidelines that whether you can choose follow or not to follow. You have to follow, and this comes under the Article 21 of the Constitution for the fundamental rights. Okay, for I'm sure everybody is aware that for fundamental rights, directly you can approach the apex court or high court directly. So that's a very serious thing here. So all the organizations are all the even smaller size organizations, they have to follow this act. So the main the aspect why this act was there, it is related with the any individual to empower them with their rights there, with the data rights, and then the accountability has been fixed for the organizations who are collecting the data. And here, whosoever is providing the data, like people like me and you, will be termed as a data principal. Whosoever is collecting will be termed as a data fiduciary. So data fiduciary, they are having some accountability. And if you are not following, so there are certain penalties there. Okay, so this act is like regulating data processing. It's safeguarding the personal data privacy. So that's how. But at the same time, it has to create a balance between the privacy rights and the digital, because India very rapidly growing as far as the digital growth is concerned, digital data, digital healthcare. Okay, there is a very rapid development post pandemic. Even prior also, the pandemic was a trigger point there. So that's how this is the thing. And now coming to the comparison, many times people compare it with the GDPR, with the CCPA and other global laws, because around the globe, out of 193 countries, around two-thirds countries, they are having the data privacy law in place in some form or other. Okay, so what is the difference? So before understanding the difference, one thing is that there are certain principles on that basis data privacy is defined. Okay, so I'll name a few, like data minimization, that organization should collect the minimum data, storage limiters, for how long you are going to store the data, purpose limitation, for what purpose data was collected. Okay, lawful, fair, and transparent, that is from the data principle side. Okay, there should be some accountability. So there are certain rules, certain laws, certain principles around the data privacy. So be it's a DPDP, the Indian Act, be it GDPR, be it CCPA, these principles are same. Okay, only the implementation part differ. Okay. And then again, the coverage, like in case of GDPR, okay, it covers a digital and physical, mean paper records also. This DPDP applies only to digital data. Digital data directly collected digital are collected physical, then consequently converted to the this thing to the digital. Like somebody is taking data on some paper form, and then later on either using some software or using some Excel or mere clicking that form and storing that will come under DPDP Act. Then comes other things, like in case of penalty, there is a difference between GDPR and this thing, DPDP Act. In case of DPDP Act, there is a provision of penalties up to 250 crores. Okay. In case of this one, GDPR, that is like from 20 million or 4% of the global turnover. Okay. And I'll give one more example related with the difference. Like here in DPDP, there is a like below 18, the child, above 18, the adult. Okay, and in case of child, parental consent is required. Okay, and that's very strict. Okay, in case of GDPR, that thing even starts from the 16 is up 16 there. So that's how implementation parts may be different, but the basic principles remain same. Okay, certain laws like GDPR is termed as a golden regulation because they are very strict. Okay, and at the same time, the CCPA, they are bit this thing because here the penalties are absolute. in GDPR, it's relative. In CCPA, there is a entry level, like okay, up to I think some $10 million or something. Some entry level is there. If that company, like in case of smaller organization, certain things are not applicable. So that's how there is a difference between the DPDP and other laws.
So I understand that a lot of work has been going on for a couple of years, and finally it's become a law. And I wanted to throw a curveball question at the later part of this. So just someone who goes back to manual, does it apply?
Mhm.
If it does the
In
entire
case of
operation
manual,
manually?
yeah, in case of manual, DPDP Act won't apply. But again, because there are other laws will be applicable.
All right.
Okay, other laws related with the breach of trust, because you are given the data as a healthcare organization, me as a patient, sharing data with the trust that you will keep it safe. So if that data you make intensely or non-intensely available to anybody else, then it's a breach of trust. Okay, so then I can approach the respective court or forum for that one. Okay, consumer, I'm your consumer.
Right.
Okay, so I can approach the consumer forum also. So other laws are applicable, but as far as the DPDP Act is concerned, in case of physical, is not applicable.
Perfect. So coming back to my second question, see, home care is tricky. When we talk about data in home healthcare, basically we're talking about hospital data and the med tech companies that you're working on. But home care is a very informal, unregulated, I would say, fragmented ecosystem. So
Right.
how do you make
Mhm.
sense of it? I mean, um, what are the hidden gray zones in home care if you look at it that way? There's so many caregivers, last mile people who actually collect data, things like that. So can you throw some light on that specifically
Okay,
for home
gray
care?
areas. Okay. So as far as the gray areas are concerned, I'll start with the use of uh, mm, applications like WhatsApp and uh, uh, mailing servers like Gmail and others. Okay, so in whatever experience exposure I have, these things are very common. Okay, and these are being used by the caregiver and by the family members of the patient. Okay, so use of WhatsApp for patient communication is not allowed at all. Okay, because they are informal, they are unencrypted, like audit trail. Okay, they have not been designed. The WhatsApp and most of the email servers are not designed for medical data sharing. Okay,
Hmm.
and they're not compliant. Okay, with the secure data principles and other guidelines which are suggested in DPDP Act. Uh, Next part comes with the caregivers using the personal phones, our photos, our notes. Okay. So because these mods, they are not having the access control, there is no policy, there is no control on the data leak. Okay. And the main thing is like liability is always on the organization. It is not on the employees who are working. Okay. So here, how organizations are going to keep the control there. Okay, so that's how these things are strictly prohibited as far as the DPDP Act is concerned. Uh, One more aspect is related with the verbal or blanket consent.
Hmm.
Means, okay, in case anybody from the family is giving consent, uh,
Right.
in case of any adult, that is invalid. In case of children, or in case of certain patients who are physically or mentally not capable, in that case consent can be given by the family members, but there is a process for that one. Okay, so this is also the verbal and any kind of blanket consent means okay, for the entire process or the whole treatment, and that way if consent is taken, then it's a big no-no. Storing patient data in any Excel sheet or any Google sheet or any form is again violates the data security obligations under this act. Okay, and again, when you are storing data on any of these things, whether it's WhatsApp or Gmail, so there is no defined data retention or data deletion policy, because that is again mentioned there. That is by the act as well, and there are certain sectorial regulations also in case of healthcare. There are like since it's a state law, so there are a certain guidelines from there also. NHA is also working on this thing. So there are certain sectorial laws also for the retention and the deletion, because here the data principal has right to for deletion. So data principal can request for the data deletion, and then organization need to delete. Okay. Remote team sharing the data via email or USB drive, that's again not allowed. Okay, that's a gray area as far as the home healthcare is concerned. Using third-party apps without any kind of agreements there. Okay, so the liability is on the organizations. Okay, and all the penalties and everything will be for the organizations who are providing the service there. If they are taking help of any other organizations, like they are having some technology developed by some third party, so they'll be treated as a data processor. So in case of any data breach, the liability is on the data fiduciary, who is like having the purpose and means to collect the data. But what they can do, they can sign a contract and transfer certain responsibility to the data processors. Like suppose if they are storing the data, then it's their responsibility to secure the data on the server using various ways there. Okay, they need to encrypt the data, they need to create the access log, and so many things there. Okay, so that way. So these are the certain areas. Okay, and the most important thing is uh, will be the related with the training of the staff. Okay,
Mm.
making them aware that what is good, what is bad, what can create any issue as far as the data privacy law is concerned. So these are few points which I can suggest. Mainly
Right.
is related with the way data is collected, because there is no formal way. In case of hospitals, there is a formal way, because many hospitals, they are having some management systems, this hospital information management systems, and using that data collection is there. But in case of home care, data collection is usually using the mobile devices and using the apps like WhatsApp and email, Gmail, Hotmail. So those things are not allowed under DPDP Act.
Because covered the consent part, because mostly what in home care happens is the son orders a lab test for his parent,
Right.
and
Mm,
a nurse discusses something on the go. So
mm,
it comes down to the design part of it, how you operate the entire business, right? It's very important.
right.
That's very important. Okay, so you have partly covered the liability part. The
Mhm.
it's on the data fiduciary, right? The entire thing rests on the
Data fiduciary who is control, collecting the data, who
right,
is actually, there is again a debate on who is data fiduciary, who is data processor. Okay, so very clear cut, who is having the purpose and means to collect the
right,
data. Okay, and for data processing, if data fiduciary is taking help of some other organization, so they will be termed as a data processor. Okay,
right.
in certain cases, there can be co-data fiduciary. Like take example of say not in healthcare, I can collect right now. Take example of Make My Trip. Okay, some this kind of aggregator platform. So you are sharing data with that platform, that I want to book ticket from Mumbai to Delhi. Okay, so in turn, what they do once you go ahead with the selection and booking, that platform will be sharing the data with the say Air India. Okay, because they need certain PII, certain basic information, the age, the gender, and other things, my name, and maybe my some identity proof and all. So in that case, the both organizations are data fiduciary. Okay, so this is the case. So here, based on the activities and based on the data, how it is collected and shared. So first is like this has to be defined, like what is your role, or whether you are a data fiduciary or a data processor. All the technology companies, Okay, they are data processors because they are not having the purpose and means to collect the data directly. They are doing it on behalf of the data fiduciary, which can be any hospital or home care organization or anybody.
So, I mean, this is one of the most interesting aspect I was thinking of. If we just flip the story, any home care company could use DPDP as one of the, it can use as a trust signal, because if they are
Right.
providing, right? So that could be
Hmm.
one of the differentiator in the home care companies. If they're following this and have the requisite guardrails, uh,
Right.
then that will actually place them ahead of some of the
Exactly,
competitors
exactly.
also.
Right,
Right.
right, right. Because right now, majority focus to for the DPDP is revolves around the 250 crores penalty, up to 250 crores. There are various this thing,
Right.
250 crores, 200 crores, 150 crores, 50 crores. Okay, so again, all the crores are a big, really big figures and huge enough to stop the operations. Okay, uh, but that is one part because one side this act is looks very difficult, but on other side it is very simple. When you have intent to implement it, it's very simple. I'll say one statement like if organization can very confidently say we protect your health and your privacy both. Okay, so if you are in a position to say this statement,
Hmm.
then it is going to make the difference. It is going to because there is awareness among the population related to data. Okay, and they are very soon they are going to demand this thing. A reason being the increased number of cyber crimes because that again a database until unless I am not having your data I cannot win your trust, and until unless I cannot win your trust, I cannot make you do certain things like OTP and other things from you. So data is very important. Okay, so you can say secure data is equal to safe care. Okay, so these
Hmm.
kind of things, if organizations can make part of their reach out plan, their branding, their whatever. Okay, so this is the thing. This should be linked with the care. Okay, because that care of your privacy, care of your data is again equally important. Okay,
Right.
so and in this way again, if you are of course you are not working independently, you are having certain tie-ups with the hospitals, with the other pathologies and pharmacies. Okay, so in case of these kind of partnership, uh, if your organization, home healthcare organization, is having data privacy in place, then there are chances that even a bigger organization would love to partner with you because nobody wants to breach the data. Whatever data breach happens, it's not from the organization side. Based on my experience working in this sector since last 25 years or so, many times people say that this organization is selling the data. I'm sorry, they are not selling the data, but there are loopholes which allows your third party, in certain cases, the employees, okay, based on because I have been studying the cases related to healthcare in under GDPR. What all cases were there? So in many cases, there were certain loopholes which were, I'll say, um, which were misused by either inside or outside employees or somebody there. Okay, so that's how if it's part of there, and then it's like it will future proof your operations.
True.
It will give a lot of confidence you as far as the data processing is concerned and the other aspect is concerned, and at the end it will empower your workforce also to give them the confidence. But anything bad happens, then all the legal process, nobody wants to get involved with that thing. All the expenses, the mental harassment, and everything is there. So not only the penalties, there are other many benefits are there.
So, coming to the last question, we are running out of time.
Okay.
So,
Okay.
if I'm a home care owner,
Okay.
let's get tactical. What are the, three practical steps I could take? The basic
Okay.
compliance,
Mm-hmm.
I would take as a home care
Okay.
owner or a healthcare owner, I would say,
Mm-hmm.
to be on the right side of the law.
Okay. Okay. I think you mean to say what preparation and what
Preparation,
they
yes.
should
The
start. Yeah.
basic
Yeah.
three steps initially.
Basic three steps. Okay. First of all, you need to understand how data is collected, by whom, where it is stored, and how it is shared. Means from where the data is coming, where you are storing, and with whom you are sharing. Okay.
Right.
So if you are mapping all the personal data flow, okay. So that's how you will get the idea that where the gaps are. Okay, where you need to be very careful. First of all, in wherever you are storing the data, you need to tag like which data is PII, personally identifiable information. Okay, this personally identifiable information, it starts from either independently or combination. Like I'm Sujeet Katiyar. There might be many Sujeet Katiyars, but Sujeet Katiyars born on any particular this 7th August are very less. Okay, and then the year. So that's how the combination also is there. Okay, so you need to identify all the PIIs, even your IP address, because many times the applications are storing the IP address as well.
Right, true.
Okay, so that is again PII. The cookies, that is also PII. So you need to keep track of all the fields which are personally identifiable. Okay, then comes the consent part, because that is very important, and consent has to be very it should be clear, it should be specific, it should be informed, unambiguous. Okay, so and it should not have something like, okay, you are taking consent for rest of the treatment and rest of the things there. So the consent mechanism is very much important there. That should be the you need to identify. Okay, and the day it will be implemented, whatever data you are having already with
Mhm.
you, you need to inform the data principals, means your patients, your clients, that right now I am having this data with me, and from along with that notice, you need to provide the consent mechanism, using which you get the consent, like in future I can process data for this purpose.
Right.
Okay, so these are the things. And again, I mentioned organizations should start using the secure communication and devices, and refrain from using WhatsApp, emails, and other things. Last but not least, training the employees. Training is very, very
Very.
important, because here in India, we very easily we share personal information with others. So that's how it applies here as well, also in the organization as well. So we need to educate them that the personal information of our users is very important, and why it is important, that everything should be shared, because what kind of consequences, okay, forget about the act point of view, other, because we are dealing in a very sensitive area.
Right.
Many times certain diseases are not to be disclosed with rest of the world, because down the line patient will either get cured or something. But again, once these things are out, this can impact the personal, professional, social, many ways. It can impact your user, your patient there. So these are certain things, and again, it's going to be significant data fiduciary, because healthcare, all the organizations who are collecting sensitive information in volume will be termed as a significant data fiduciary. So there are certain more obligations there. So these are few things which they should start immediately. Okay, because it might take few more months to for enforcement of act, but once it's enforced, and from that point, if you are starting, then it might be too late for you.
Right. So, the three key takeaways from this talk I can think of is like audit, it's very important, gap analysis,
Right.
design the system accordingly, and then train your caregivers and everyone who's involved in the operational aspect of it, or maybe even data storage. Also, simplify the consent part of it, right? The three key
Exactly.
takeaways
Exactly.
that I can
Right.
think of at the moment. Thank you,
Okay,
Mr.
otherwise there
Sujeet.
are many. Okay, there are many things there,
Yeah,
but
yeah,
still,
yeah.
these are the
Two.
things to
Yes,
start.
yes, yes.
Okay, and then after, yeah, you will come across many other things there, and then because it's sir, it's just about following the guidelines. Okay, no need to worry. There is a panic because of this 250 crores and government is not going to penalize to collect the money from you. Make sure
Mm.
it's just the fear they are creating that you should be following it. It's just a strict request to follow, not more than that. Yeah.
Okay. That brings us to the end of this talk. Thank you, Mr. Sujeet. It was a pleasure having you, and it was very insightful. And maybe it will take another couple of sessions with you to fully understand the
Definitely,
impact
I'm
that's going
always
to
there.
have on
Yeah,
home care.
yeah,
And
sure.
thank you so much for taking time out.
My pleasure.
And
My pleasure.
thank you.
Welcome, sir.
Thank you.
Thank you.
Thank you.